Good morning, everyone, and welcome to our webinar this morning, Litigation Survival Guide. This is the first in the series of three webinars that we are running this autumn in place of our usual in-person Think House Foundation events. My name is James Hall, and I'm one of the co-chairs of Think House Foundations. I'm a senior associate in the employment team here at Gowling. And as you have joined us today, hopefully you'll already know that Think House Foundations is our program aimed at in-house lawyers at the more junior end, ranging from trainees and paralegals up to lawyers around 5 years PQE. I hope you will be able to join us for the other webinars that we are running in the series this week, both tomorrow and on Thursday, at the same time as today's webinar. Tomorrow's webinar will be delivered by my teammate Jasmine Coyne on returning to the office and some employment law issues for you to consider. And on Thursday, we have hot topics in data protection delivered by my colleague Claire Van Ristel. And if you're unable to join those webinars live, then there will be recordings available. So do take a look at those when they come through to your inbox. So on to today's topic. Litigation Survival Guide. I'm joined by Anna Lelliot, a senior associate in the Disputes Resolution Group here at Gowling. She's based in our Birmingham office, and Anna is going to give you her do's and don'ts and talk about whether to litigate or not in the first place. And also she's going to touch on privilege and without prejudice. So, I mean, hopefully you agree, and that's why you've signed up today, but understanding what you need to do when faced with the prospect of litigation is really important for you guys as in-house lawyers at all levels. So we really hope you'll find today's session useful. Anna is going to speak for around 30 to 35 minutes, and then we'll have time for questions at the end and look to draw the webinar to an end at around 11:15. Before I hand over to Anna, I have a couple of housekeeping points to run through. Firstly, if you'd like to ask a question, then we are using the Q&A function on Zoom, and you'll find that at the bottom of your screens. So click on that and type in your question, and it will be directed to Anna and I only. So other webinar attendees won't be able to see your questions. And we would emphasize there's no such thing as a silly question, and we'll do our best to deal with as many as we can before we close today. And if we can't get to your question, then please do leave your sort of contact details when you ask it. I think there should be the option for you to do that. And then we'll look to follow up with you afterwards if we can't get to your question today. And secondly, as I mentioned earlier, the webinar will be recorded. You'll be sent an email with the recording either later this week or next week. And then please feel free to share that with colleagues who you think may find it useful. And then finally, at the end of the webinar, there'll be a link in your browser to complete a very short feedback questionnaire on the webinar. Please do take a couple of minutes to fill that in and send it back to us, because we do read them and we do use them to shape future sessions. So we're really grateful if you could do that. We'll also send a link to the feedback form when we send the recording of the webinar in case you don't have time to do that today. So that's enough from me. And without further ado, I'll pass you over to Anna.
Hi everybody, thank you for that introduction, James. My name's Anna Lelliot, and as James mentioned, I'm one of the senior associates in the Dispute Resolution Group here at Gowling. I'll be talking to you about Litigation Survival Guide. As a litigator, I appreciate that litigation and going to court is not something that most people like or enjoy, so hopefully I'll be able to share some tips with you to alleviate any fears. So the first thing that I will do is go through some practical tips, the do's and don'ts. I will also talk to you about whether to litigate or not to litigate and what alternatives you might have if a dispute arises. I will touch upon privilege because obviously it's extremely important to you as in-house counsel, and also on without prejudice. So kicking off, my practical top tips, I've set them all out here. There are 5, and I will go through each one of them in turn. And to summarize, they are: don't dither, take into consideration service and protocol, try and put together a chronology. Think about insurance, whether you have any, could it help you? And also give some thought to limitation and jurisdiction. So starting off with the top tip, don't dither. I think that's a very pithy way of saying that, you know, time really is of the essence and is very short. So when you're dealing with a claim form, for example, you need to act promptly, but not in haste. You have 14 days to file an acknowledgement of service and a further 14 days to file a defence. So it is extremely important that if you are unfortunate to receive a claim form, have a look at the dates and keep a note of when you receive the claim form and how, and I'll touch upon that in a minute. But diarise the times when you are due to respond. Because the consequence of ignoring a claim form is that the other side may make a very straightforward procedural application to have judgment in default entered against you. The only way that you can get rid of that is to make a court application to set aside the judgment in default. And to give you an idea of the cost of that, a very straightforward application to set aside the judgment in default can be as much as £10,000. So really, it's not worth taking the risk. So do put those deadlines in your diary and act on them. In terms of a letter of claim, if you receive a letter of claim rather than a claim form, usually at the end it will say when a response is required. Again, diarise that. If you're about to go on holiday, or there is holiday season, or the time limit that is being asked of you to comply with is unreasonable, then again, don't just simply ignore it and go, well, this can wait. Put together a very short response to say that the time that you've given us to respond is unreasonable. We can't get back to you, but we will endeavour to respond within the next month or whenever it is you can, and then diarise that. What I would say is that usually 14 days is reasonable. In other circumstances, it could be as much as 21 days. 7 days is rarely considered to be reasonable unless there's a contract that is payable on demand, and in certain circumstances, it may be considered reasonable. The consequence of not responding to a letter of claim isn't as bad as not responding to a claim form, but it can still be tricky, because the other side could issue a claim without any further recourse to you, and that effectively puts an end to the pre-action correspondence period and your opportunity to resolve things without resorting to court. And one of the things that a letter of claim will usually say is that if you ignore it, you could be penalised in costs. So the court rules that we use in litigation make it very clear that the parties are obliged to engage in pre-action correspondence and try and resolve things without going into court. So if you're basically ignoring the letter of claim and not engaging in that, then the court does have discretion to penalise you in costs. So there's no need to be in that situation. Try and resolve the dispute beforehand, and do engage in a letter of claim, even if it is just simply to say, we don't think you have a good claim, try again. So my next top tip is in relation to service. So the claim form needs to be filed at court and served on you. So what I would say about service is that I mentioned earlier the court rules, the civil procedure rules. They're effectively a guide to litigation, how to litigate. They're extremely prescriptive in respect of service. The rules set out how the claim needs to be served, on who and when. There are different ways of service. One of them, obviously, as you imagine, is first class post. However, the court rules haven't moved so far ahead that, for example, faxing a claim form is still a valid form of service, whereas email is not, and I'll touch upon that in a minute. So what you need to do when you receive a claim form is look and keep a note of how it was served on you and when, what was served with it, there should usually be a response pack. So it would include the standard defence form and acknowledgement of service form. That should be with it. Also have a look at whether the claim form is filed as it is, with the brief details of the claim set out within, or whether it says particulars of claim to follow. Particulars of claim are basically details of what the claim is that you're facing. And they're usually a separate document, and sometimes the claim form will say particulars to follow. They should follow within 14 days. If you get a claim form and it says the particulars are to follow, but then no particulars do follow, and that time just lapses, then you might have, for example, the right to make an application to the court to strike out the claim, to basically say it's an abusive process, you've not received the particulars of claim, and it should be struck out. So that is why it's really important to have a look at what's come in with a claim form. Other things to look out for when you receive a claim form is have a look if it has come in by first class post, keep a copy of the envelope. I know obviously in the digital age that sounds really archaic, but a colleague did recently have a claim form that was posted allegedly by first class post. However, the correct postage wasn't paid and it was 40p short. When it arrived on our client's premises, the client paid the difference, so the 40p. And when they came to us with this issue, we immediately were of the view that actually, paying for postage, incorrect postage, doesn't constitute valid service because it's not been served by first class post because it wasn't the correct amount of money. So what that meant for the other side is that service was invalid. They had to abandon the claim and reissue. When we say reissue, that means going back to the court and paying a court fee. In that instance, the claim was for more than 250,000. So the court fee was £10,000. So a very, very expensive mistake to make. So if you are receiving a claim form, watch out and keep all details about how you received it. And if you are thinking of filing and serving a claim form, then make sure you pay the correct postage. I mentioned earlier that email is not a permitted form of service. It isn't unless you have the consent of the other side. So what that means is that you have to get the other side to expressly say that they agree to you serving a claim form. So if you're about to receive one and you receive it by email and you've not consented to receiving being served by email, then there is scope to say that actually that was not validly served and they need to try again, which means that the time doesn't start running until valid service is made. Service could be implied. Usually that happens when you file a court document by email, or you put your email address down on court documents. So give some very careful thought whether you want to agree to service by email. And as I've mentioned, it can happen by fax. So if you work in a business that still has a fax number, and certainly some businesses still do, and usually a fax number is on letterhead and or in email signatures, then be aware that you could be served by fax. Next top tip is protocol. So this relates to letters of claim and letters before action. Again, the court rules set out various different pre-action protocols that explain the conduct that the parties are obliged to follow, and set out the various steps that the court would normally expect parties to take before commencing proceedings. And the idea of these is that if you follow these steps, then hopefully you should come to a resolution without needing to issue court proceedings. Now, a word of caution on protocols generally is that there are 13 different protocols. So when you receive a letter of action, and if it does refer to a protocol, make sure to check that it is the correct one. Don't assume that it is. So to give you an example, I recently acted for a client in respect of a contract dispute, and they received a letter of claim referring to the debt protocol, but the debt protocol doesn't apply to business to business in the commercial context. It only applies to business to consumer. So it wasn't the correct protocol to use, and certainly it was helpful to have the upper hand initially on responding to the other side to say, well, look, you can't even get the correct protocol. Try again, we don't even have to respond to this. So do check that they are using the correct protocol. If there isn't a specific protocol, then the protocol to go off is the practice direction on pre-action conduct and protocols, which is just the general protocol. And the consequence of non-compliance, which I have touched on, is that the court has a really wide discretion to look at the way in which the parties conducted themselves in the pre-action process. And if there's been a party who's not behaved reasonably or is in default because they haven't engaged, and the court can order them to pay indemnity costs, which is effectively paying costs on at a higher rate. It can deprive a party of interest that it would otherwise receive, or it could award interest on a lower or higher rate, depending on who it's penalising. So it is worthwhile looking at that and following it closely. Tip number 3 is chronology. So this is a really practical tip, and it's one that is extremely, extremely helpful to do at the outset, because it will help you and your boss and everybody that you're working with. And if you're going to instruct external lawyers or barristers, it's an extremely helpful document to go back to, because you know, I've no doubt that you have lots of things on your desk at any one time, and when you're dealing with a dispute, it can be sometimes difficult to remember all the various different details which do matter, and the facts. So what a chronology does, it helps you get to grips with what happened and who was involved, and you're effectively creating a table of the date, the event, and any document that supports it. And in effect, it helps you to distill the facts and understand what happened, so that when you start looking at what causes of action are available, you know exactly what your facts are. And to use a bit of a cooking recipe analogy, your facts are sort of like your ingredients. So if you want to pursue a certain cause of action, you can only do so if you've got the relevant ingredients. If you don't, you need to think about what other causes of action you have. And having a clear chronology right at the outset really, really helps focus the mind of everybody, including the client. Because if they start sort of saying, well, I want to, you know, pursue this, but the facts that you have don't allow you to do that, then again, you'll be able to find that out straight away by looking at that chronology. One other top tip from a lawyer, a litigator, is that this is literally the first thing that I do every time I get a new case, no matter how big or how small. So if you prepare one, it's going to save you time, and it's also potentially going to save you money, because if you were to instruct a firm of solicitors, they wouldn't have to do one, they would have the benefit of yours. If you want to save some more money and time, then put an index together and prepare all your documents so that they can be followed through with your chronology, which means that all your paperwork is in order and you have all your documents ready to go and look at. That very neatly brings me into looking at evidence. You can see I've put lots of little stars around the word evidence, because it is extremely, extremely important in litigation for obvious reasons. Now, what I would say is get all your documents in order. Usually in this day and age, that's emails, but think about it in the most simple way possible, is that you're putting together a story of what happened, who said what and when. And once you have all that, you're then in a much, much better place to decide what you're going to do next. So in terms of evidence, you're looking at documents, contracts, meeting notes. If your business does a lot of work on various different apps, or if you have WhatsApp messages or any other type of social media that you use in the business that might be relevant to the dispute, then that's also a document that you need to think about. Next tip is insurance. I don't really have much more to add than what's up on the slide in front of you, other than to remind you to check whether there is an insurance policy in the business that can help you out, because usually most businesses have some sort of insurance in place. They may have legal expenses insurance tagged along onto that, or a standalone policy. If that is the case, read the policy, look at the exclusions, and speak to your broker and have a look at whether you have the benefit of an insurance policy that might be able to assist with resolving the dispute in the most cost-effective way. If it is covered, then notify the insurer, because if you don't do so, then the insurer may reject the claim. What I would say in terms of my own experience of dealing with insurance companies in the commercial litigation context is that it is extremely helpful to do this, because I dealt with a case a few years ago where there was a dishonest employee and director and shareholder, and there was a big dispute. It was all very embarrassing, and he'd taken a lot of money out of the company, happened to be the finance director, and so it was a difficult situation. Financially, it really did hurt the company quite badly. But because the company had the benefit insurance, they were able to recover the sums, and it didn't affect their cash flow going forward. So it really did assist. But in the longer term, what that meant is the insurers were part of the negotiations to settle the claim with the fraudulent director. So that was, a different dynamic. So do check insurance. It's very important. And I suppose a complete freebie here, if you ever end up in a dispute in a personal capacity, also check your insurance, because the likelihood is that you might have legal expense insurance with a policy without really knowing it, so it's worth checking. Now, limitation and jurisdiction. Now, limitation, as you probably know, is what you need to do is check, is it about to expire? So if you're looking at a contract claim, then you need to be looking at when did that breach take place. If you have a, say, a long-term supplier or customer, or there's potentially you've been, you receive a letter of claim in relation to a breach that has happened a long time ago, dig out the contract that relates to. If you have it, have a look at what the contract says, and also give real serious consideration, when did that breach take place? Because as you know, in contract, it's 6 years from the date of breach. If limitation is passed, then you might have a complete defence to a claim. If it's about to expire, then the other side may ask you to enter into a standstill agreement. Now, it sounds sort of counterintuitive. Why would you enter into a standstill agreement? Why not let just the limitation expire? Again, as a defendant, the reason you would do that is because you would rather try and resolve matters rather than facing a court proceeding against you. And if limitation is about to expire, the likelihood of you receiving a claim is much more likely, because the only way to stop time running is to issue a claim and or enter into a standstill agreement, which effectively means that as the defendant to a claim, you agree not to rely on the expiry of a limitation period from a given date, so usually the standstill agreement. So effectively, time stands still, and then if you can't resolve matters, or you give notice under the standstill agreement that limitation is going to start running again, and it starts ticking as of the date of that notice. So it is usually, in instances I've seen it work, it's quite helpful to get the parties to focus their minds on resolving the matter in the standstill period, rather than going to the cost and stress of proceedings. Jurisdiction sounds like an obvious one, but it's worth looking at whether English courts have jurisdiction, especially if you work in a multinational organisation or one that works with lots of different countries. Have a look at whether the English court is the right place to bring a claim, or does your contract, for example, make provision for arbitration? I've recently seen a contract make clear that the forum for resolving disputes is by way of an expert determination, where effectively the parties go to an expert and his decision is final and binding. And it's much more cost effective. So do have a look at what the contract says. And equally, whilst this isn't a litigation point, if you are in the business of negotiating contracts and writing contracts, do give some serious thought to what do you want that dispute resolution clause to look like? Because litigation isn't the only route, and you can put mechanisms in place to encourage the other side and both parties really to make court the very last resort. Also look at governing law, check if English law is the governing law under the contract. If not, then you may well have to get foreign law advice. I've got a bonus tip for you here in terms of evidence. I've mentioned it already. Evidence and documents, it's very, very widely defined term, documents, but it's extremely important in litigation. Preserving documents is key. And it's not really sort of a tip for you in your day jobs, but it's really, really important to make sure that no document destruction processes that you may have in place and routine document destruction policies are suspended if you think that a dispute is, if it's brewing or you think it might kick off, because you don't want to end up in a situation when you have to explain to a judge why certain documents that were key to a particular dispute have been destroyed. So don't destroy any documents and ensure that everything is preserved. Now, what I would say is that disclosure obligation is an ongoing one and is defined by reference to document. As I've already said, it's very widely defined, and basically it covers anything in which information of any description is recorded. So it's not just a Word or an email, a Word document, email, or an Excel spreadsheet. It covers databases, it covers WhatsApp, it also includes the metadata, which sits behind, for example, the documents that you create. So if, for example, you're dealing with a fraud claim, you can have a look at when a document was saved, resaved, modified, etc. Equally, any video recordings, voice recordings. I have dealt with a shareholder dispute where a senior executive had ended up in a fight in a bar, and that video footage was disclosable. So really don't think about it just in sort of words on a page. It's much wider than that. And then if it comes, if the case proceeds, you might be ordered to give disclosure of documents. And in England, English courts require very much a cards on the table approach, because if you think about it, if everybody knows what they face, and you have to disclose documents that support your that are relevant, that support your case, but also that support the other's case and are not helpful to your case, then the likelihood of the parties trying to resolve matters and negotiating a settlement before they get to court increases. And so I, as much as I love law dramas, my main favourite being Suits, obviously for obvious reasons, it's very, very rare in practice that somebody walks into court waving, smoking gun document. It just doesn't happen because, as I say, it's there's an ongoing duty of disclosure. It's extremely onerous, but that makes it even more important for you to make sure that all documents are preserved and that you've got a handle on those in case a dispute arises. So next thing I'm going to talk to you about is to litigate or not to litigate. Now, obviously, as a litigator, I'm not in the habit of talking myself out of work. However, what I would say to every single client is the first point is there scope for a commercial resolution to the dispute that you're dealing with? If there is, then let's try and explore that first. And often one of the things that I have done in the past is that I work in the background and I help clients put together letters, and they then send them out without the other side knowing that lawyers are instructed in the background. But we're there to assist and to help. And if that is something that you can make use of, then do think about it, because litigation is costly, it's stressful, and we always have to weigh up the litigation risk, because you don't know what kind of judge you're going to get on the day, and it's something really to bear in mind. There are lots of different alternative dispute resolution routes that you can go down. So, for example, I've mentioned you could just pick up the phone. It can be as informal as that. If you have a good relationship, and also if you want to preserve that commercial relationship with the contractor or the supplier on the other side, then actually picking up the phone and trying to talk through your differences might be the best way around it. If that doesn't succeed, then there are other ways. So, for example, you can look at mediation, which is more cost effective. It's a bit more formal, but again, it's in that pre-action. It can be done in that pre-action stage. And so you could think about, can I reach some sort of resolution, maybe potentially give a discount to the very start, rather than incurring legal fees, which effectively would be the same or less, or more than the discount I'm prepared to give. So what I would say is that do consider alternative dispute resolution, and as solicitors, we have to consider the cost benefit analysis, and if it's not worth litigating, we will tell you, because it's not in our interest for you to do that, and we won't want to run a case that isn't worth fighting, or it's not cost effective to do so. Sometimes, however, even if the cost benefit analysis is it's going to be extremely costly to bring proceedings, and financially the numbers are sort of telling you, well, don't litigate. There may be other reasons why actually you've got no choice, you have to litigate, and that's more about where there are significant non-financial benefits to taking a certain course of action. So to give you an example, I have acted for financial advisors who have and are bound by restrictive covenants, and it is very rare for a financial services firm, for example, not to take action to enforce its restrictive covenants against financial advisors who are leaving, because what they don't want to be seen as in the market is being a soft touch. They want to be seen as somebody who they have these restrictive covenants in place for a reason, and they are prepared to stand by them, so they will spend the money on litigating. And often where you have something like that, or where your reputation is being questioned, then that is a situation where actually, even if there are no financial benefits, you have little choice but to litigate. Other ways of resolving disputes, I've put on there statutory demand and winding up. Obviously, word of warning, there was a suspension during the COVID period. It's recently been lifted, I think, on the 30th of September, so you can now serve stat demands and winding up petitions, but it is a very, very blunt tool. So it's to be used with caution and only for unpaid and undisputed debts. So if it's for an unpaid invoice that is not disputed, then actually sending a statutory demand or threatening to wind up is an effective way of getting paid. But for a corporate, it has to be a debt of more than £750, and for an individual, it's £5,000. And if they don't respond within 21 days to the statutory demand, that effectively is evidence they can't pay their debts as they fall due. So you can then go on to serve them with a statutory, a winding up petition, or a bankruptcy petition. Now, those steps are not to be taken lightly, because the consequences are very serious. So if you are petitioning for a winding up of a company, that petition will get advertised, and it will affect the credit rating of the business. So that is the reason why the threat is very serious, and lots of companies do pay up on the back of that. So again, to give you an example, I think in about February 2020, just before COVID, I was acting for a large construction company that was owed a significant amount of money by a UK business owned by they had a Chinese owner, and we wrote to them demanding payment. They refused. We served a statutory demand, and again they didn't respond. We threatened a winder, and what the response that we received at that stage was, the owners based in China, COVID-19 is ravaging through everything. We can't get to the bank, and what we didn't know then is just how serious it was. So we persisted, and the debt did get paid. So it was, very effective, and I would probably say we're quite lucky to have got in there. But you can see that it can be effective, but it must not be disputed. If there is a dispute, or there is an inkling of a dispute in relation to a statutory demand, then it's best not to go down there, because the court can penalise you, and you could face an injunction to stop you presenting a winding up petition. So it's not to be used lightly. Obviously, there's also termination. If it's a contractual dispute, have a look at what your contract says about termination. Is there a termination for convenience clause? If there is, make use of it. If there isn't, think about whether there's been a breach. Does the other side have to remedy the breach? What sort of notice do you have to give in respect of any breach under the contract? If there are provisions then in the contract about notice, then do follow them by the book. One very quick thing that I'd like to say in respect of termination is repudiatory breach. So a breach that goes to the heart of the contract, sort of the big whammy. It doesn't terminate the contract automatically. And I've often seen clients who think, well, they did this, it was, obviously we couldn't possibly continue. It isn't obvious, it isn't automatic. And what it does mean is that you can decide whether to accept the breach and terminate, or whether you want to affirm and continue, because actually you need to get the job done. So you have to decide to accept the breach, and then you have to tell the other side and say, follow the notice provisions on that. So I'm going to touch very briefly on privilege, because I know that my colleague Jo Rhodes has relatively recently done a talk that covers privilege, which is a topic all in its own right. So I'm not going to talk about it in any great detail. You'll obviously be aware that there's litigation advice privilege, and then I'm going to concentrate on litigation privilege and what it means in the litigation context. It's effectively confidential communication between a lawyer and a client, or between either of them and a third party, made for the dominant purpose of litigation that is reasonably contemplated or existing, so it's continuing. So if you are in pre-action, or you think there's a contract that's going a little bit awry, it might be, and you're contemplating litigation, it might be that litigation privilege applies in that context. Most communication and exchanges that happen between lawyers in the litigation context are covered. What I would say is just a word of warning: if you are around, discussing settlement, which is great because you're about to resolve the matter, but equally there is certain case law coming out now that if settlement discussions are discussing commercial aspects of a deal specifically and only, rather than the legal aspect, then they may be considered to be non-privileged. And what you don't want to do is you don't want to waive privilege inadvertently in settlement discussions. And so use labels. So if something is privileged, mark it as such. If you are providing advice in respect of a dispute or some litigation in a memo or in board meeting minutes, again, label it as such. Labels aren't definitive, but they are helpful. If you can, keep any commercial advice separate to legal. So you could provide a memo setting out what's happening in the dispute, mark that as privileged with litigation privilege on top of it, private and confidential, and then possibly refer to it, which means that any minutes and memos that are disclosable and that refer to that privilege documents, the bits that are privileged can be redacted if it goes to court. It is extremely easy to muddy the waters if you're working in-house. So as I say, try as much as possible to think about what is the advice I'm giving, who am I giving it to, and think about the different hats that you're wearing when you're giving the advice. And my number one top tip, probably trumps everything I've said so far, is don't write anything down that you wouldn't want to end up in front of a judge. Not in an email, not in a letter, not in a WhatsApp or a text message, because sometimes, especially when you're in a dispute with others, people can get very hot-headed and type things and send without thinking, and it's not pretty when it has to end up in front of a judge. So try and communicate that word of caution across your organisation and exercise it yourself. Without prejudice, I'm sure you all know what this is. It's effectively another rule that operates to keep material out of the court. And effectively, it's used so that genuine attempts to settle litigation are prevented from being used in evidence against you as an admission in court. So, and the aim is very much to encourage genuine attempts to reach resolution. That's why they're used. I often say that court proceedings are like a train. You get on, once you're on there, those deadlines are set by the court. You have some room to maneuver. There are some deadlines you can agree with the other side, but more or less you're on that train to destination court proceedings. Alongside that, we also have without prejudice discussions. So we're trying constantly, we're doing sort of a two-track approach to try and settle things if we can. And what we don't want to do, for example, if you deny the claim and that's your open position, but you don't want to incur the costs of court, of lawyers, the time, it's just too much. And you think, actually, do you know what, there's a nuisance amount that I'm willing to pay for this to go away without admitting liability, so I'm going to put this offer forward. And what you don't want the court to do is to have a look at that and say, well, you wanted to settle, it must be that you're admitting liability, and that's why you mark it as without prejudice. Insofar as without prejudice savers to costs, now that effectively means that you can refer to communication that in relation to settlement, but only after liability has been decided and you're talking about costs. So, for example, if you've made an offer to the other side and they refused it, but then went to court and failed to better the offer that you put forward, then you might want to tell the court about that and say, well, actually, we could have resolved this 6 months ago if only they'd accepted my very reasonable offer. And so therefore, I don't think I should have to pay their costs and they should be penalised for that. And the court will take that into account. So, I mean, I tend to use without prejudice savers to costs more frequently now, because actually, if there is a genuine attempt to settle, and I want the court to see that we've gone over and beyond to try and negotiate things, but the other side is being unreasonable, then why not have a chat about it at the stage that we're talking about costs? I'm not going to talk about it here because it's very technical, but there is also something called a Part 36 offer that you can make, which has certain cost consequences. So that's also something to consider, and it can be done at any stage of the litigation, including pre-action. And so sometimes you'll see without prejudice savers to costs used less because parties prefer to use the Part 36 rule and putting offers on that basis. So I think that wraps it up. So if you have any questions, I can see there are some questions.
Thank you very much for that, Anna. That was fantastic and some really good tips for us all to be thinking about and some good takeaways for everyone. Thank you. Yeah, we've had some, we've got a couple of minutes for some questions. We've had some good ones through. So I think if we just kick off with hopefully a relatively easy one. It's from an individual talking about if you're dealing with a litigant in person, they've used the incorrect protocol, and you've actually advised them of this, and then they go ahead and issue the claim anyway. How do you think a court would deal with that in terms of concerned with the claimant's error?
So that's increasingly more difficult because, and I think in the last 7 to 8 years, we've seen more litigants in person because court fees are extremely, it's very, very expensive, especially to issues people try and do it themselves. I think there is a court guide for litigants in person that I always used to send to litigants in person and say, look, here it is. This is a litigants in person guide. Have a read of this. You can't advise them, but you can point them in the right direction. And I think as long as you have set out in your correspondence and said, this isn't the correct protocol, and made it clear and sent them the correct protocol, whether by way of link or you can print it out and send it to them, I think that should suffice. But one of the things I would at that stage be thinking, and obviously looking at the merits of your claim, is whether you have the option of making an application to strike out because the claim isn't, has no prospects of success. So that's something to consider, is can you strike it out? The courts are sympathetic to a point with litigants in person, but they, just because you're a litigant in person doesn't mean that you're not obliged to comply with the court rules. So, have a think of what possibly a strikeout application might work in the instance.
Great. That's really helpful. Thanks, Anna. Okay, we've got time for just one more quick question, I think, and that is, you mentioned as a potential alternative to litigation having without prejudice correspondence or conversations with the other side. Somebody's asked, are there any specific formalities that you use when you're having that sort of conversation? Do you need to get that confirmed in writing first or anything like that?
No, labels are helpful, but it's really the substance of what's being discussed. If there's a genuine attempt to settle, in terms of conversations, I would, before you start the conversation, make it clear that it's on a without prejudice basis. If the person doesn't understand what that means, then just explain to them that it's confidential and you won't be able to refer to it in court later on. And that's it. You just have to make a note that it is a without prejudice conversation and it's a genuine attempt to settle. If you are having those conversations, even in the commercial, more informal context, I would encourage you to keep a note of who said what, because it might be later down the line that either the other side tries to rely on that conversation or something might happen. You want to have a record of it. So do mark it down, but do just make it clear that you're having that conversation on a WP basis.
Great. Okay, fantastic. Well, I said we just run over for a couple of minutes, so we'll call it a day there. I'd like to, thank you to Anna. And as I said at the beginning, if you do have time, just to go through that feedback form, which should come up on your screen after we close the webinar, please do. And hopefully see you at the webinars tomorrow and on Thursday morning. So, okay, have a great day, everyone. Thank you.
Thank you. Thanks. Take care.